In my years as an asset protection attorney, I've seen million-dollar real estate portfolios crumble because of 5 critical LLC mistakes that leave you completely exposed. In the next 11 minutes, I'll show you the exact mistakes that have cost investors their properties so you can fix them before they become serious problems that could cost you everything. And number one is funding of the LLC. What does funding mean? It means you actually put the asset into the LLC. When it comes to real estate, when it comes to real property, the title records, the chain of title is the definitive representation of who the owner of that asset is. So what I often see is that people purchase homes for rental in their individual name. The reason they do it is because financing is cheaper and easier. They're getting a conforming mortgage that will only be issued, the mortgage will only be given if the individual is the initial purchaser of that property. If you are purchasing property with a commercial loan or you're purchasing it for cash, you can set it up where you do the closing so that you close on the property in the LLC name. But that's not possible for many buyers who do want to get those conforming mortgages. You purchase the property in your personal name, you have the intent to move it into the LLC, and you just say, you know, just create a document that says I'm contributing this property to the LLC. That is not enough. You need to do a deed transfer in the chain of title to move that to move that real estate into that LLC. There's potentially problems with that, right? Depending on what state you're in, there could be reassessment that's done on a change in title. I've seen this in, I'm not licensed in California, but I've talked to California attorneys and California clients. There's a reassessment that is done if there's a change in beneficial ownership, right? If you're moving the property from your personal name into an LLC that's owned by you and a partner, then that could trigger a reassessment. So you need to be cognizant of those things. It's sometimes not a free lunch. Other states don't care, retitle it, no issue. Other states like Florida has they call it a stamp tax. If you transfer real estate, there's really very limited exemptions for the stamp tax. You transfer it from yourself into an LLC, that stamp tax can apply, and it can be, you know, upwards of more than 1% of the value of the property. There's some, you know, changes in the way or differences in the way that's calculated without getting into those state-specific details. If the property is not titled, if it's not deeded in the name of the LLC, then you are still the owner. There may be ways around it, right? The way around it would be you've got a management company perhaps that you can't transfer the property into an LLC because, like, if you've got a VA loan or an FHA loan, or if it were some sort of lender who objects to that transfer, then you may be able to achieve a similar level of protection by having a management company, which then leases to the tenants. But if you don't transfer the property into the LLC in the deed records, the owner of the property would be the one that's responsible, and then that's you. So you're taking on that liability. So that's mistake number one that people often make. Second issue I see again and again, right? Let's say you did purchase the property in your personal name. Then you did do it correctly. You transferred it via deed into the LLC. You got over the humps of related to reassessment or the stamp tax or your lender or whatever else it was. And you're like, I'm good to go. Yes. The second mistake is you don't update your insurance, right? So who is on the insurance policy? Is it a liability policy? When you got the policy, did you do it as a landlord policy or did you do it as an individual policy? Because if you got it as an individual homeowner's policy and then you're using that property for commercial purposes, that's probably going to be excluded, right? You need to have the right kind of insurance, and the insurance needs to be in the name of the LLC. So the LLC is the insured. You will often have it where there's an additional insured. The additional insured may be your mortgage lender, right? That's often an additional insured. It may also be that you as an individual are an additional insured. So you want to make sure that you have the correct wording, naming of your insurance who is the insured, and you want to make sure that you've got the right level of insurance. So let's go over a little scenario here, right? You purchase the property in your personal name. You get the initial insurance policy. You just are saying it is your personal home or personal residence. Then you move it into the LLC. You get a tenant. You sign a lease. The tenant slips and breaks a leg because you failed to shovel the sidewalk, and they sue for $200,000. You're like, all right, that's fine. I've got $1 million policy on this. No problem. And then your insurance company denies the claim because that individual sued your LLC. That's the one who was on the lease. And it was a commercial accident, right? You were making money from the property and you didn't have a landlord policy in place. So there's this coverage mismatch, right? You thought you had insurance, you're paying insurance premiums, but you're not covered for that kind of liability. So your LLC protection here could be worthless because you now have the insurance didn't pay the claim. There's $200,000 which needs to be or needs to be paid. If you don't have it, then that individual could get a lien against the property. Whatever equity you have in the property would be subject to those claims. So this is one that is a very small thing, and it may not come up on your radar, but you need to be aware of it. So that was number 2, making sure the right kind of insurance, titled, and the insured is properly named as the LLC, as well as likely yourself. Number 3 often happens when there's a change in the ownership of the property. You move it from yourself, your personal name, into an LLC. And this common mistake is that the lease is not in the name of the owner of the property. It's not in the name of the LLC. So who's the contract with? Who's the one who's responsible? Well, probably you and the LLC. Sue everybody is often the approach here. But if you are the counterparty on that lease, then you're absolutely going to be sued, and you could be held personally liable for lease breaches, for damage that occurs under the terms of that lease. So this one's there's some paperwork, right? There is no free lunch. You want to redo that lease on renewal, or potentially in the middle of the term. If they're not on a lease, you just rent it to them in an individual capacity on a month-to-month basis. You want to get a new lease in place where the landlord, where the renting entity or the leasing entity is the LLC between the tenant and the LLC. You got to get an LLC bank account. You got to make sure the rent checks go into the LLC bank account, and then you got to make sure that expenses and the like are paid out of that LLC bank account. So let's dive into number 4. And this is really the financing aspect, right? The transfers, the funds that went into the LLC are not properly recorded, and there's confusion. Imagine this, right? A family decides, hey, we're going to invest in some real estate together. The father contributes $200,000 cash into the LLC. Sister transfers the duplex that she owns into the LLC. And then the brother promises to manage the properties that are in that LLC and puts in $50,000 as well. So now in the future, fast forward, and they're looking to do a refinancing. And nobody can agree about what the heck everyone's ownership percentage is, right? The father says that he only contributed $100,000 into the LLC as a capital contribution, and the other $100,000 was actually a loan, but he hasn't received any interest on it. And then the duplex transfer, well, the LLC never actually took title to the duplex. It wasn't actually titled in the name of the LLC. There may be some problems related to what was the value of that duplex at the time. And then the brother says that he really deserves more than his small percentage of equity because he's doing all of this management work. And so this creates confusion. There's no clear record of, was it a loan? The investments that individuals make into an LLC should have some value that's agreed to by the members. So they say, well, the duplex was worth $300,000. We got an appraisal on it.
dad contributed the 100,000, brother contributed the 50,000, and then the equity of the company should be divided up in line with those capital contributions. There is some wiggle room there and ways that you can, for like the son who's a manager, to get that son and manager some additional compensation or equity, but it can become very complicated. So what is everyone's capital contributions to the company? What does it represent in terms of their ownership interest? Very important for so many reasons, a lot of tax related reasons, not going to get into here, but have the conversation. These sloppy decisions or, handshake deals really typically don't end up where you want them to end up. It ends up with this conflict within the LLC itself. So making sure everyone's on the same page, properly recording contributions to the LLC as well as distributions from the LLC, and making sure everyone is on the same page. Huge mistake that I see over and over again. So the number 5 is not having an operating agreement. The operating agreement is the Bible for this LLC. It needs to contain a lot of different things. So I created a whole video on operating agreements and the things that you should include in yours. And so I encourage you to watch that video.